which you probably haven't used before. Okay, so first of all, I'm Linda Geller-Schwartz. I'm with the Voting Rights Coalition set up by the League of Women Voters. I am the state policy advocate for the National Council of Jewish Women. And in that capacity, we work on court issues. So I'm thrilled to be here to talk to you about why federal courts and the judges who sit on the bench matter to women, children, and families. We're going to talk about the problem of judicial vacancies and how you can get involved and influence the process. We talk always about our legislators and our president and our governor, but we don't talk that much about the courts. And this is an occasion to do so because they're very important. So some of you may know that the National Council of Jewish Women launched our benchmark campaign about 15 years ago because of the critical role of the courts. People weren't paying enough attention. And they affect every issue in our lives, from voting rights, as the League well knows, to the separation of religion and state, which seems to become even more of an issue on a daily basis, from abortion rights to LGBTQ rights. And we learned that we could influence, in some ways, the types of judges being appointed to the bench. Today's demonstration will demonstrate firsthand, it's interactive, just how much courts matter. And we are excited to do this with the help of our great co-sponsors, the League of Women Voters. Hands up. Of course, everybody belongs to everything, right? But the ACLU, right? NCJW, right? And Florida Why Courts Matter Coalition. And in a sense, you're all part of that. And I must thank and introduce my co-presenter, Marcy Ball-Florida, a civil trial attorney with Lytle, Ryder, Smith, Ivey, and Von Rath. Marcy is a native Floridian who graduated from Clemson University in South Carolina and the University of Florida School of Law. Her practice concentrates on issues of medical malpractice, nursing home negligence, it's quite important, and personal injury and wrongful death. She is active in a number of professional associations and community associations. Lytle, Ryder, Smith, Ivey, and Von Rath are also one of our co-sponsors, and we thank them for that. First, Marcy is going to give you a brief introduction to the court system. For those who are unfamiliar or a bit rusty on the court system, she'll update you on it. After that, we are going to provide you with the details of an actual case that was decided by the courts in the past. And each table here is going to be a bench of judges. You're going to act as judges. You're going to decide how this case should have been decided or should be decided. And you're going to rule on the case. You'll then find out what the actual ruling was, and you might be surprised. Finally, we're going to talk about the current situation of judicial appointments. So I'm going to turn it over to Marcy now.
Good evening, everyone. How's everyone doing tonight? Good. As Linda said, I'm with Lytle, Ryder, Smith, Ivey, and Von Rath, and my firm and I are really excited to be a part of the events hosted by the League of Women Voters about why courts matter. So as Linda indicated, I'm going to give you the Reader's Digest about the court system in the United States. So the court system in the United States is set up of state courts and federal courts. State courts is where I practice primarily, and the types of cases that are heard are divorce, child custody, probate having to do with wills and estates, traffic court, personal injury. Those are the types of cases that are heard in the state courts. The federal courts, on the other hand, they deal with issues having to do with the federal government, the U.S. Constitution, federal laws, or when there's disputes or controversies between the states. And we're going to be focusing primarily on the federal court system tonight. You're going to be deciding some cases that were in front of the federal courts. And the cases in front of the federal courts are very important because they decide or create what we lawyers call legal precedent across the country. Now, one of the other distinctions between the state courts and the federal courts is that federal judges have a life term. a seat for life. So whereas state judges may just serve for a few years if they're not elected or reappointed, federal judges are appointed, subject to confirmation from the Senate, and then they're there for life. So these judges, they have the ability to decide issues that literally cover generations. Now, most of the time, the media attention goes to the decisions of the highest court in our country, the U.S. Supreme Court. We've all heard of Roe v. Wade or Hobby Lobby. But one of the takeaways from tonight should be that the lower courts in the federal system also decide really important issues, like Linda mentioned, voters' rights, rights for women to make decisions about their bodies, workers' rights, things that affect us as mothers and sisters and husbands and our families every day. Now, the federal court system is a three-tiered system. The bottom tier is the U.S. district courts. That's the trial court level. And there's 94 of those district courts in the United States. There's at least one per state, and that's where the cases start. And typically, there's one judge that's at that level. The next tier is the U.S. Circuit Court of Appeals. That's where they're appealed to. And then finally, the United States Supreme Court, which is the highest court in the land. So in the United States, there's 13 circuit courts. Now, if you look at the map, you're going to say, Marcy, there's only 11. Those are the numbered ones, but the 12th is the D.C. Circuit, and then the 13th is the head of all of the all the federal circuits together. And you can see Florida is here in the 11th Circuit with Florida, Georgia, and Alabama. So when decisions come down in the 11th Circuit, all three of those states are under that jurisdiction. Now, unlike the district courts, which usually only have one judge, the circuit courts have a panel of 3. So if you think about these circuits throughout our country, so few members, these elite judges, how much power they wield to make decisions across our country. Now we're going to talk about, I think the next slide is, and we're going to talk about the breakdown of the cases. But in reality, so few cases are taken by the Supreme Court of the United States. And for that reason, the lower court decisions are really important, because if the U.S. Supreme Court says we're not taking this case, then whatever the circuit decided, that's the law in the land for those states that are in that circuit. So if you look at this pie graph, 90% of the cases are decided at the U.S. District Court level. So that's the lower level. The circuit courts, the appellate level, that's just under 10%. And if you look, the Supreme Court doesn't even warrant a piece of pie on our slide, because their 1/10 of 1% is decided by the Supreme Court. That means about 100 cases per term. So in our country, a lot of the most important decisions are being made by the green guys and the red guys here on our pie chart.
You will each have the case before you. You are, in a sense, the district court, each of the tables, right? You have to, and the table captain has a set of questions for you that you're going to discuss individually. You have 15 minutes to answer the first 4 questions. The 5th question involves a vote at your table. We need a majority decision. If there's a dissenting decision, a minority, you can also report on that. Okay? So after 15 minutes, I will say, over, okay? And you will move to the 5th question. Your table is a panel of judges, and you are the chief judge. Congratulations. You will guide your fellow judges through the decision-making process. You need a majority of the panel to issue a ruling. And once the deliberations have ended, you'll present your table's decision and rationale, as well as any dissenting votes. Each judge needs to introduce themselves around the table. You need to know who you're talking with. Don't allow any one judge to monopolize the time. Give everyone a chance. And you will see you have to look both at the laws and the facts. You have to consider both. And there's a series of questions here, which I will not read now, but your table captain will read to you, all right? So here is the case. The case is Standridge et al. Versus Union Pacific. The Union Pacific Railroad Company has approximately 48,000 employees working in several states. Approximately 1,300 of them are female union members. Union Pacific estimates that 450 of those women are of childbearing age. The company provides health insurance benefits to its union workers. The health insurance plan provides coverage for a variety of prescription drugs, including preventative drugs such as blood pressure and cholesterol-lowering prescription drugs to prevent heart disease, hormone replacement therapy to prevent osteoporosis, immunizations to prevent diseases such as influenza and tetanus, drugs to prevent the contraction of contagious diseases and disease progression in HIV-positive patients, drugs used exclusively by males to prevent benign prostatic hypertrophy, I should have Marcy do this, and drugs used exclusively by males for erectile dysfunction. The plan also covers a variety of preventive medical services, including routine physical exams, cancer screening tests, smoking cessation treatment, and yearly dental exams and teeth cleaning. Sounds pretty good. The plan has exclusions and limitations related to fertility, infertility, and family planning. It excludes coverage for sterilization procedures and for infertility treatments. It also excludes coverage for prescription contraception to prevent pregnancy. All 6 of the available methods of prescription contraception are used exclusively by women. Oral contraceptives, IUDs, Depo-Provera injections, barrier methods, the contraceptive patch, and the contraceptive ring. The plan covers prescription contraceptives only if ordered for a non-contraceptive purpose, such as the treatment of skin diseases or menstrual disorders. So, a group of all-female union employees of Union Pacific, including Brandy Standridge, hence Standridge et al. Versus Union Pacific, who use prescription contraception, at least in part for the purpose of preventing pregnancy, without insurance reimbursement from the plan, have filed a lawsuit against their employer. They allege that Union Pacific has discriminated against them by providing health insurance benefits that selectively exclude all FDA-approved prescription contraception, in violation, here comes the law, of the prohibition of sex discrimination in the Civil Rights Act of 1964, as amended by the Pregnancy Discrimination Act of 1978. They also argue that unplanned pregnancies have a negative impact on society. Union Pacific argued that it should not be required to cover prescription contraception because of the financial impact. It suggested that denying all contraception actually results in equal treatment of men and women. The employer also argued that fertility is not a medical condition related to pregnancy, and that it covers only treatment related, not preventive medicine. Okay, turn the page now. We come to the relevant law. Title VII of the Civil Rights Act provides in part, it shall be an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's sex. The Pregnancy Discrimination Act, known as PDA for short, clarified that the terms because of sex and on the basis of sex include but are not limited to because of or on the basis of pregnancy, childbirth, or related medical conditions, and women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes, including receipt of benefits under fringe benefit programs as other persons not so affected but similar in their ability or inability to work. So the legal question, which is the 5th question on the list, what you'll be doing now is dissecting this case. The table captain will help you take you through the analysis of the case and through 4 different questions. And then at the end you'll be asked this question. In light of all the facts, does the Union Pacific Railroad Company's policy of denying coverage for all contraception violate Title VII as amended by the PDA? Now it sounds complicated, but when you start getting into it, you'll see, you probably have some ideas already, okay? Okay, so go ahead, it's up to you. I should say this is not, there's been changes because of the ACA law and recent rules, etc. We'll come to that afterwards. But this was 2005-2007 case of where the law was.
Health care coverage discriminates against women.
Yes. Think about the legal principle and the facts, not about your personal feelings about what happened in the case. So as a judge, you have to try to separate your personal feelings from what you read.
That's over the counter. So I mean, I would look at it that condoms are not prescriptions, such as the pill, IUD.
Makes it possible for him to have intercourse. Think about it. They give him something for, Viagra and something for the erectile dysfunction, so that the woman can conceive.
So, the point being that if a woman were to become pregnant,
There's a point at which they can't birth.
and whereas that's not
They are murdered. Those children are put in garbage bags and just left because the abortions. Well, that's another decision.
No, but 50% of children are unplanned.
So, okay, what
in
percentage of the companies?
In 1903, about 20 years later, the rate of violent crime among young men went down, and the rate of sexual activity, promiscuity, and all that stuff, pregnancy among young women went down. But
You want to read it again? Okay.
Repeat the question.
Do you think the Pregnancy Discrimination Act was intended to apply?
Oh, all right. Same thing. Not really. You take us working.
A lot of difference and change what the legislator actually did.
So, should we assume that they didn't mean to exclude contraception from the amendment?
I think so.
I think they meant to.
I disagree. I think that if they meant to include it, it would have been whether it's not about insurance, it's about the law. Whether this.
Can everybody please take a vote now on the last question, and the table captain to record what the majority and minority decisions are, if there are. What we're going to do is I'm going to ask one table to give me an answer to the first question. I'm going to start with that and see if there are any other tables who had a different view or something they wanted to contribute. So we'll have two tables on each of the questions, and then we'll discuss where we got to at the end. Okay? Everybody got it? All right. So the first question is, do you think Union Pacific's health care coverage discriminates against women? Can I have one table volunteer their views on that?
We think this is legally questionable. And it affects the ability to work for women, but men are not impacted.
Okay. So you think that Union Pacific's health care coverage does discriminate against women? That's what you're telling me?
Yes.
Okay. Does everyone agree with that, or does any tables came to a different conclusion? Yeah, everybody said yes. Okay, interesting. Okay.
We all have a certain bias, so.
You mean you're not neutral judges?
No.
Not neutral judges in this room?
We don't have a trade.
Yes.
So for everybody in the room that said it didn't discriminate against women, did it ever come up at your table that the company would not pay for contraception for men, i.e. condoms and vasectomy, and they wouldn't pay for contraception for women? So how are they discriminating against women? Did anybody feel differently than their whole table, who felt like, you know what, they are treating everybody equally? Anybody feel that way?
The effect was discriminatory because the consequences are much more severe for the women than for the men for unwanted pregnancy.
And in coming to that conclusion, did anybody rely upon anything specific in the law itself that allowed you to come to that conclusion if you looked at the law and your facts?
Yeah. I was looking at the last line where they talk about the ability or inability to work, where if a woman becomes pregnant for at least some period of time, she will have a complete inability to work, whereas a man would not. If he wanted to, he could work the whole time.
Okay, great. Okay. All right, let's move on to the second question. Does the health care plan cover any preventative services? If so, do those services prevent conditions that are more or less serious than pregnancy? Now, I know one table over there had a discussion about that. Deb, can you tell us what you found?
We found, yes, that it did cover preventive services. In fact, the fact pattern said it did. We also found that pregnancy was sometimes more serious and sometimes not as serious as some of the preventive medicine conditions that were covered.
Okay.
So,
All right. Anybody else want to contribute their views on this one?
At least equivalent.
Did you have the same at this table?
We said they were at least equivalent. We said they were at least equivalent.
At least equivalent in terms of seriousness.
Yes.
Okay. Did anybody think less serious? No. Okay. Got a pretty uniform commission. Okay. Do you think the Pregnancy Discrimination Act was intended to apply to contraception coverage? That's a good question.
You said no.
All right, you said no. Tell me why. What did you say? Why no? Yes, now tell us.
It talks about pregnancy and thereafter. It does not talk about preventing pregnancy in any way.
Okay, so it's only the period when you're pregnant
Pregnant
and
or
thereafter,
thereafter.
not preventing pregnancy. Anybody else feel differently on that? Yes, right with this table.
We didn't necessarily think differently, but I think we all would have liked to know more about the legislative history of the PDA, because it was a little bit ambiguous. And somebody at the table pointed out, it says include but are not limited to. So we felt that opened the door that just because it doesn't mention contraception doesn't mean it wasn't intended to be part of it.
You would like to have the record behind you?
We would like to know more about
the base,
yes.
the intent.
Yes. It may have been, as one of our judges said, an unintended consequence.
Right.
Yeah,
McCall?
we ended up calling it ambiguous double entities. That was fun, because, yeah, just ambiguous double entities, because it's very,
Wasn't clear to you.
it wasn't clear.
And that's what we said, it was not clear. So, we're down to the fourth question. Is contraception gender specific and does it matter? All right. Is contraception, is gender specific?
Yes. Because, well, we were talking about the fact that, you know, the contraception is covered, or sterilization is covered for the man?
No, it's not.
It's not? No, it doesn't say that.
So what was covered and what wasn't covered? The plan excludes limitations related to fertility, infertility, and family planning. It excludes coverage for sterilization procedures and for infertility treatments. It includes all the 6 available methods of prescription contraception used by women. What was not in there?
No, it doesn't say, it's not gender specific, it just says what it's not going to cover.
All right, yeah.
we felt that it was not gender specific, but that it did matter.
Okay, that's what it is. Yes.
I'm speaking for myself. To me, the problem is, no, it wasn't gender specific, but male contraceptive methods are relatively inexpensive and do not require the attention of a physician. They do not have to go through the healthcare services. They go to their local, whatever store that carries what men will use. On the other hand, women do not have this option as a rule. So, yes, in that case, the contraception may not be gender specific, but the methods required are. And the costs related to that are.
Let's go to the final results. I'm going to go from table to table, and you tell me how you rule. In light of all the facts, does the Union Pacific Railway Company's policy of denying coverage for all contraception violate Title VII as amended by the PDA? Okay, yes or no? How did you decide, Jen?
We voted yes.
You voted yes. Was it a unanimous or just majority opinion?
Majority.
And what, there was a dissent?
There was 1%, yes.
And the dissent, what, did they give reasons for the dissent or not? Or would they like to give reasons? Penny, obviously, right?
I'm not gonna hide under the table. If I was a strict constructionist and reading just what's on the paper, that's my opinion.
Okay.
But I'm happily overruled.
All right, no, it's fine. We've got a majority dissent. Okay, how about here? Somebody give.
We voted no.
You voted no.
We were strict constructionists.
You were strict constructionists.
What does that mean?
We said that it applied to both men and women, and therefore.
So you're saying the way the law was written, without any more information, you read it as.
We said we didn't like it, but we didn't have to.
We didn't. Okay.
Violated Title VII.
Male contraceptives, vasectomies, anything like that, as well, and also anything for women.
Okay. Okay. All right. So we have two different opinions here. All right. How about here? What did you decide?
We were 6 yes and 3 no.
Wow. Okay. Interesting. Sophisticated group here. Yes. Tell me. Did you have any reasons you wanted?
We actually didn't take the vote until just a few seconds ago.
Oh, okay.
I'm sorry, we really don't have a coordinated decision.
Would anybody at the
But we
table
had
like to
say.
give any reasons why they think yes or no? Yeah, Fran?
I think that all of us were struggling with that, and I don't think any of the yeses were easy yeses.
No.
And for me, I go back to the point that I made prior, which is this ability or inability to work. To me, that's the only way that you could possibly make it a yes. Because otherwise, I think it's a no.
I don't see at all, I voted no, because I don't see anywhere in there that it talks about contraception. It talks about what happens after she's pregnant, but it doesn't talk about preventative.
Okay.
That's why I said no.
Okay, great. Table back there?
We all agreed that it doesn't discriminate against women. We felt that it didn't give men and women equal conditions in marriage.
Okay, so you were looking at that clause in the last. Okay, good. So you had a unanimous decision there?
Yes.
Okay. Yeah.
We had 4 yes and 2 no. I did not take part because I knew the result. And primarily the reasons that have already been given, our yeses felt very strongly that the spirit of the law required that it be found discriminatory, and the strict constructionists on our panel felt very strongly that it was not covered.
Silly, is it the river? No. All right, just joking. Yes, okay, thank you.
And I'm not identifying them.
No. We'll give you escorts to your cars. Right. Our last table here.
Okay, we all voted yes, and my own opinion was that
Yeah, I can't hear you.
sorry, we all voted yes on the last question, and my personal opinion on it was that the third line of the PDA says affected by pregnancy, childbirth, or related medical conditions. And to me, the related medical condition is a need for contraception.
So if from your point of view, and a
my
strictly constructed kind of analysis, it's there, you're saying, right? Okay. Anyone else? Yes.
Well, one other thing is that they were perfectly happy to supply treatments for erectile dysfunction, which in a sense promotes pregnancy, and which is a related medical condition. And so denying contraception says that they are actually going to wade into the fertility-related questions, but they didn't want to wade farther along than helping out the guys.
Thank you, everyone. That was very good. Seriously, you did a great job. Now, you want to know the decision? No, you don't. We're not going to tell you then. No. So we're going to hand out the decision, and Marcia's going to go over it.
So if you haven't gotten to the bottom line on the 2 pages, the district court and the U.S. Court of Appeals did not agree. So let's start out with the lower court, which is the U.S. District Court of Nebraska, 2005. At the district court level, the judge compared the effects of the risk of pregnancy to other types of conditions where medication is covered. The question is whether the plans treat women who have the risk of pregnancy less favorably than the plan treats other people. That is, do the plans cover medicines or medical services to prevent employees from developing diseases or conditions that pose an equal or lesser threat to employees' health than does pregnancy? The court went on to say there's some evidence that at least one of the plans covers prescription medications for male pattern baldness. Definitely something that's a lesser threat to pregnancy. The plans provide prescription medications for male erectile dysfunction when, quote, medically necessary to persons over 18 years of age and in limited quantities of 8 pills over 21 days at retail and 36 pills per 90 days at mail. The plans also provide prescription medications to lower blood pressure, reduce cholesterol, replenish hormones, reduce nicotine dependence, prevent allergic reactions, and immunize against flu, tetanus, rubella, and childhood diseases. The plans further provide routine physical examinations to prevent a wide variety of health problems and routine dental services to prevent dental disease such as tooth decay. It is clear that the plans do cover a variety of medications and medical services designed to prevent diseases or other medical conditions that pose an equal or lesser threat to employees' health than does pregnancy. So the conclusion of the lower court, the district court, they found that the company Union Pacific's failure to cover these prescription contraceptives did constitute a violation of Title VII as amended by the PDA. In holding that the coverage was discriminatory against women, the district court cited the language of the PDA, the purpose of the enactment, like the table in the back was talking about, the Equal Employment Opportunity Commission's interpretation of the PDA's application to prescription contraceptive, and reasoning from other district court decisions in the federal courts. The district court rejected the plaintiff's argument that unplanned pregnancies have a negative social impact. I know we talked about that at this table a little bit. They didn't rely upon that argument for their ruling. And it also rejected all of the company's arguments. So the district court held that Union Pacific violated Title VII as amended by the PDA because, quote, it treats medical care women need to prevent pregnancy less favorably than it treats medical care needed to prevent other medical conditions that are no greater threat to employees' health than is pregnancy. So for the tables that said yes, there's the good news. On to the other news. So 2 years later, now remember we talked about before that the district courts only have one judge that has the decision, but at the circuit court level, 3 judges. So that's why you're going to see the majority of the opinion, i.e. 2 of the judges felt one way, and then the dissent was the 3rd member of the panel who felt otherwise, and the majority rules. So,
do you have, were there women on this panel?
I don't know the answer to that. It's a good question.
I don't know.
I don't know.
What are the basis to appeal something like that? Do you have to have, I mean, can anybody just appeal, or do you have to have a really good reason?
No, usually the appeals have to do with the ruling of law. In other words, it can't just be the way the facts were interpreted. So there's a dispute about how the law, and the circuit court of appeal decides whether they're going to take the appeal, and they did. And again, if the U.S. Supreme Court had wanted to take the case, then they could. But if they didn't, so this is the law in this particular case. So this was in the 8th Circuit Court of Appeals 2 years later, and the majority reversed the district court's decision. The majority panel of the 8th Circuit Court of Appeals, which includes the state of Nebraska, stated, based on the language of the PDA and previous cases, the majority found the PDA does not encompass contraception. The majority found that contraception, like infertility treatments, is a treatment that is only indicated prior to pregnancy, because contraception actually prevents pregnancy from occurring. Furthermore, they found that, like infertility, contraception is a gender-neutral term. Therefore, the majority ruled that Union Pacific's denial of coverage for contraception for both sexes did not discriminate against its female agreement employees in violation of Title VII as amended by the PDA. The majority determined that the district court was incorrect in using the comparator, quote, medicines or medical services that prevent employees from developing diseases or conditions that pose an equal or lesser threat to employees' health than does pregnancy. The majority found that this case concerns Union Pacific's coverage of contraception for men and women. The majority found that the proper comparator is the provision of the medical benefit in question, which is contraception. Union Pacific's health plans do not cover any contraception used by women, such as birth control, sponges, diaphragms, intrauterine devices, or tubal ligations, or any contraception used by men, such as condoms and vasectomies. Therefore, they ruled that the coverage provided to women is not less favorable than provided to men. Thus, there's no violation of Title VII. It was reversed. Now, the dissent, the one judge on the 3-panel dissented, noting that he, so we do know the answer to one of the questions, that the dissent was a male, he agreed with the district court's framing of the discrimination inquiry, and therefore agreed with its conclusion that Union Pacific's policy discriminated against women under Title VII as amended by the PDA. The dissent noted that all of the medical effects of the policy exclusion are borne entirely by women, and that Union Pacific did not identify any health insurance policy that would provide coverage for non-prescriptive contraceptive devices available in drugstores and gas stations nationwide. So there you go. That's why federal courts matter.
How did you feel about this? Not good? Yes, Christine?
And my biggest thing was listen to your first instructions, that it said I had to listen to the laws and the facts and not just go with feelings, and so it gave us a sense of what a judge has to do to be fair and just and try to listen to the facts. So I thought it was a very good exercise. Thank you.
Okay, thank you. Any reactions to any of the case? Those decisions, the way they were rendered? Yes.
I just
Upset?
was wondering,
Yeah.
if the plan had given contraceptives to the men, would that have changed the decision in a phenomenal way? And would that happen necessarily because women need the same kind of thing? I don't know.
But we don't know, but potentially it could have.
I think it would have probably gone
Yeah.
the other way.
It probably would have.
Yeah.
But to me, the big difference was, for men, getting contraception is a relatively inexpensive and readily available phenomenon. You know, I mean, it's what we did. For women, it's a whole different story.
Except they included vasectomies in the analysis.
Oh, what we do. The reality is that generally, a fairly reliable contraception was available cheaply to men, not to women.
Question.
One more, and then go on. Yes.
Maternity leave, was that addressed in any way?
Not in this.
Should it have been?
I think this is kind of a maternity. I think that was sort of dealt with elsewhere. I don't, there was, as I was saying earlier, there used to be a Pregnancy Discrimination Act, Pregnancy Disability Act, which in effect was the only way women could really get maternity leave before any unpaid maternity leave time was offered. So that was a whole other different thing. One might say an equally or even more discriminatory situation. Okay, so you can see how important judges are, how much they matter. Same laws, same facts, interpreted differently. Over the past decades, the federal courts have played a key role in issues of reproductive rights, contraception, and abortion. Marcy has a sheet that she's handing out there, which lists the important cases that have gone through the Supreme Court on this, everything, including Roe v. Wade, but there's Griswold v. Connecticut, there's the modern cases, the more recent cases. It'll show you the role the Supreme Court has played on this. We've been talking about the district and appeal courts here, but the Supreme Court ultimately, in many of these cases, are so important that they do take something. Now, after this this case, we know, and because if you read the newspaper last week, the president has issued a new rule on contraception. The ACA was designed to correct some of the problems you saw in this case, right? So that women could get contraceptive coverage without, first they could get it, and secondly they could get it without co-pays or deductibles. And that was the rule. But the president issued a rule last what he called a final rule, although the ACLU is taking him to court on that, as are some others, that exempts a wide range of employers from the requirement under the ACA that they offer birth control to their employees without co-pays or deductibles on the grounds, and this is what it is, of the employer's religious or moral beliefs. It is a really quite general, open-ended kind of statement. And it's very easy for the employer to do it. There's nothing particularly has to file. The question is how many women, you know, the original ACA is estimated covered millions of women for birth control. And the sense is that now, maybe millions, I've heard tens of millions of women will no longer have access because we don't know how many employers will take advantage of this. Many may. You'll see the Hobby Lobby decision discussed there. At that point, it was only applied to privately held for-profit companies who could exercise their religious and moral beliefs. This new rule opens it up to any company pretty well. So, you know,
Has it been, did the ACLU already file?
I believe they filed last week.
So is it in effect or it's not in effect?
There was no stay.
There was no stay, but I don't know what's happened. So far, but you know, all this is pretty new, so it was only been a few days. And we'll see, and the Health and Human Services is taking comments, but why they're taking comments on a final rule is not entirely clear. The legality of all that is very confusing. Bottom line is, and this is an issue that not really the courts, we seem to be going backwards on some of this. So it's really important to have a federal branch that represents the diversity of our nation. Both demographic and professional diversity are important because it improves the quality of justice and competence. The law is the law. It sits there and you have to interpret it. But as you can see, depending on who interprets it and their understanding of the facts, their understanding of the world, the real world experience, you might end up with a different result. At the current situation, there are a significant number of judicial vacancies that I want to talk about. And I want to start off with the process of appointment, because that's being contested right now. As Marcy indicated, these are lifetime appointments. Once you get there, you will stay as long as you want, pretty well. Prior to 2017, there was a process, and we still have it, I think, but there's a lot of debate about whether we'll keep having it. As you can see, the home senators send names to the White House. The president makes a nomination. It goes to the Senate Judiciary Committee with a hearing and a vote. The full Senate then debates and votes, and you get a confirmation. And there's something called the 30-hour rule that they had, where you're supposed to debate and consider this for 30 hours. In between here, between the president making the nomination and the Senate Judiciary Committee hearing and vote, there was something called a blue slip, which literally was blue. A blue paper. I would love to have paper. I don't have it. I've seen pictures of a blue slip. And really what it was, the idea was that the president consulted the state senators to get their approval, and they would sign off on if they approved. It may not be someone they really love, but they could live with that person, let's put it that way. And that has not always been effective. Sort of his interpretation has come back and forth, but there's always some consultation involved. And for the most part, President Obama, previously President Bush, tried to get the senators to sign off on it before it proceeded, because if it didn't have a sign-off, it didn't proceed. Well, things are changing like a lot of things. First of all, let us say that during the last session, the last administration, not that many senators were confirmed. In fact, when Obama left office, judges, excuse me. When Obama left office, there were 108 court vacancies, about double the normal amount. So the president has about a lot more judicial vacancies to deal with. The pressure at this moment is on Senator McConnell and Senator Grassley to do away with the blue slips so that they could just pass through all these judges without getting approvals from both senators in the state, with minimal consultation or just ignoring it. So Senator Al Franken, in the moment, is trying to delay or stop the nomination of a judge in Minnesota. This is going to be a test case, and we'll find out whether they get rid of the blue slip or not. But, you know, yes. Did you want to say something, Steph?
No, I was just going to say the president. I can't call him president. Trump tweeted yesterday. So Trump tweeted yesterday that the two women, Sonia and Ruth, are very sick and they're going to be gone soon. And he described their health, the status of their health yesterday.
No comment. Well, the bottom line is there's going to be not just Senate. Maybe we don't just know about the Supreme Court at the moment what's happening, but we do know that there are a lot of vacancies around at the moment. Leaving that aside, at the moment there are 149 federal judicial vacancies at the district and appeal level. There are 62 emergencies, and emergency is essentially, the emergency case appointment is defined, I'm sorry, a judicial emergency is a classification. It's quite specifically defined. It involves the volume and the type of cases and the urgency of the cases and the backlog. This whole thing is a calculation, but there are that many emergencies. When we don't have judges, everything, now you have no justice, and everything gets backed up. All the cases, you know, justice delayed is justice denied. Well, we really have that at the federal level. But unfortunately, and the number of judicial emergencies has quadrupled in the past couple of years. So this is complicated by the fact the president is busy naming federal court nominees in droves. He's nominated 50 nominees, but not necessarily those that have come up through the states. He has a list from elsewhere, I think, that he's nominating. And the judges he has are being confirmed much faster than the early period of Obama's. He's confirmed 4 circuit judges now. I mean, we have 149. That hadn't happened as quickly in the Obama administration. So let me see, we'll go on here. As you can see, in Florida, there are 10 federal judicial vacancies. Yep, and 9 emergencies. So that was a few days ago. I mean, things changed, but that was pretty well where we're at. And that's consequential. So, you know, we need judges. We need judges. We clearly need judges. The question is who the judges are that we nominate. So let me just go over this. Unfortunately, among those 50 nominations, 77 have been heard by the Judiciary Committee and are waiting for full confirmation. Several have been appointed. 7 have been appointed. 1 associate justice, which is Gorsuch, to the Supreme Court, and 4 judges for the United States Court of Appeals, 2 judges for the United States District Courts, but some of those judges have caused a lot of strong reaction because they're not even vetting them. They're trying to get them through. So, for example, Justice John Bush was confirmed to the U.S. Court of Appeals for the 6th Circuit. He wrote to compare abortion to slavery and referred to them as the 2 greatest tragedies in our country. He also indicated that he strongly disagreed with same-sex marriage. He's mocked climate change and proclaimed, and he was known to have proclaimed, the witch is dead when the thought of the ACA might not be enacted. That was his reaction. Justice Ralph Erickson was confirmed to the 8th Circuit Court of Appeal. In 2016, he was one of the 2 judges in the country who ordered the federal government not to enforce health care non-discrimination protections for transgender people. Last week, Amy Coney Barrett was advanced by the Judiciary Committee to the full Senate. She was questioned as to why she spoke for a fee to the Alliance Defending Freedom Group, which is a nonprofit group that has been labeled a hate group by the Southern Poverty Law Center. So there's serious concerns if the blue slip goes. And if the blue slip goes, the only thing that's left is pressure that we can exist as people, as active groups, as voters, right? That's about it. That's all we can do. In some cases, even the Bar Association, at least in one case, they designated someone as unqualified. I'm not sure that's going to stop it. So, here they are. I'm sorry. No, I'm lying you, not in tears. Here are your senators. Your senators, for once, both of them have done a good thing. Here, you can feel better, okay? They wrote the president at the beginning of the this administration and said, we would like you to reappoint renominate three of the judges that were nominated by President Barack Obama for appointments to the courts in Florida. And they said these are qualified people. They didn't get their hearing last time. Please move them forward. They're moderate, middle of the road people. There hasn't been an answer. That's several months ago. But I would have thought, here's it, bipartisan, working together. But we haven't had an answer yet. I wrote an op-ed, which is one of the things you guys can do to try and encourage the president to pay attention to this, which was published but didn't have any effect yet. Okay. So, what can you do? Well, we can do this elsewhere if you want to educate more people. We're happy to do that. When the time comes and we see some nominees from Florida, we haven't as yet. If they are nominees that seem distinctly inappropriate, not reflecting a diverse course or a diverse court, or one that would be one that we feel comfortable with, we have the right to talk up and tell our senators, even if the blue slip process is not there, make your views known. And hopefully the blue slip process will still be there. We can work with the coalition on why courts matter, issue press releases. We just have to watch what's coming down the path, because it's consequential. That's what this is all about. It's consequential who sits there, because it affects our lives on every issue that we live with. And that's essentially why we have done this. And of course then there's all the ACA issues that are coming up, and all the reproductive rights issues that are coming up that we'll have to keep our minds on and keep our attention on.